Good afternoon, everyone. My name is Peter Neufeld. I'm a partner at Wagner Podolsky and the co-chair for this Lunch and Learn series on will challenges, along with David Friedman. You may have seen me before if you've been here at other seminars for this will challenge series. If not, pleasure to meet you. Thanks for coming. The subtopic that we're going to be talking about today is on the first court appearance. So not typically a hearing on the substance of a will challenge, but rather on some procedural and preliminary matters that is somewhat unique to estates litigation. An article in this case was prepared by Craig Vandersea and Tanisha Tulloch. That was prepared in advance of today's seminar, and a link to that article will be posted in the Zoom chat for your review. A few housekeeping notes, the same as usual. Please make sure that you have your microphone muted at all times, unless of course you're asking questions at the end of the presentation. And then after you're done that, please ensure that you put yourself back on mute. We have two presenters today, Craig Vandersea and Tanisha Tulloch, both of whom are lawyers at Tork and Mains. Craig Vandersea is a partner at Tork and Mains Trust and Estate Litigation Group. He's certified by the Law Society, and he's a specialist in estates and trust law. His practice includes estates, trust, capacity, fiduciary, and power of attorney disputes, litigation, and litigation for clients consisting of individuals, private companies, trust companies, government agencies, and other organizations. He's also a very experienced estate mediator. He's certainly given me a run for my money in quite a few mediations at this point. So we're always happy to have him. We also have Tanisha with us, another partner at the Tork and Mains firm in trusts and estates. Tanisha practices commercial litigation, professional liability defense, and of course, trust and estate litigation. Her practice includes all aspects of estate, trust, capacity, fiduciary, and power of attorney disputes and guardianship issues. She also has expertise in commercial contract disputes, shareholder disputes, commercial collections, and commercial fraud. And she appears before all levels of the court, including the Superior Court, Divisional Court, and the Court of Appeal. So thank you both for attending today. Also, a big thanks to our sponsors, the B'nai B'rith, Concentric Trust, Scotia Wealth Management, Tork and Mains, TD, as well as BMO Trusts and Estates. This event is complimentary because of them, so thank you. And if you enjoy our seminar, then we kindly ask that you consider making a donation to the B'nai B'rith Canada Food Programs in lieu of payment for this program. The link for making that charitable donation is in the chat. We'll go ahead and start with the seminar. I'm going to have Craig and Tanisha are going to start talking to us about the first court appearance. So go ahead.
Good afternoon, everyone, and thank you, Peter, for the introduction, and to Wagner Podolsky LLP for inviting Tanisha and I to speak on this topic today. Peter mentioned that there's a paper and a link, and just so you will understand what's there, the paper itself is about 15 pages, and then attached to the paper is about 6 pages of chart dealing with sample provisions to put into an order giving directions. And then I think we have, I know we do have a draft order giving directions. I think it's 6 or 7 pages as to how one might utilize provisions and what that order for giving directions might look like. And if we get time today, I'm going to take you to that order and touch upon that. So I'm going to start today. Tanisha and I have divided the topics up, and today's topic is really the first court appearance, and really 2 ways to get to a first court appearance: an order for assistance or an order for directions in the case of a will challenge. So why is today important? Why are orders giving directions important, or orders for assistance important? Because it's frankly one of your best tools at first instance to manage a will challenge and determine how you want to lay out and strategize with respect to your will challenge. A will challenge doesn't start when you're 3 steps into meeting with your client, and then you say, oh, wait a second, there's a will challenge. Okay, well, what are we going to do? Should we get this? Should we get that? From my standpoint, strategy starts when the client comes in the door and you have your initial meeting and you're finding out that there's a will challenge, and understanding that there could be a will challenge. One of the first thoughts is, what are we going to do? Is there a way that we can resolve this dispute even without going to court? Is court going to be necessary? And if we go to court, what are we going to achieve, and what do we hope to achieve? And the orders for assistance, or the order giving directions, is a mechanism, the vehicle, if you will, that can be used to lay out how you want to address the will challenge, or in the case of an order for assistance, other issues than just simply a will challenge. So it's the party's ability to craft the manner in which they want to proceed. And it's asking the court for assistance for interim and ancillary relief that will hopefully be able to lead the parties to a resolution, whether that resolution is going to be by way of settlement with or without a mediation, or a resolution if it becomes necessary to go all the way and conduct a trial. So the provisions of an order giving directions can depend on a bunch of different factors. What are the issues? Who are the parties involved? Are parties represented? Are parties under disability? What evidence needs to be marshaled in order to be able to deal with the dispute? Is a mediation mandatory? Well, it is if it's Toronto, Essex County, or Ottawa, but it might not be necessary. So how will that settlement process be worked in? How is the known evidence going to be obtained? And how is the evidence going to be utilized, or possibly utilized, in the pursuit of settlement and or the claim itself? And relief can include things like, how is one going to manage the estate? Because of course, if there's a will challenge, then the individual who's named as the estate trustee in the challenged will doesn't have authority to manage the estate. So as typically done, an estate trustee during litigation will be appointed. And then we're dealing with the collection, management, and protection and preservation of the assets. Are there assets that need to be sold because liquidity in the estate? Are there properties that are in dispute, quite apart from the will challenge, that can't be sold? So there are a plethora of issues that the parties can think about at the beginning. And an order giving directions doesn't have to be 7 pages. It could be that the parties are trying to work their way towards a resolution on evidence that can be obtained by the parties themselves, and that there is a less costly and efficient way of dealing with things. Maybe the first attendance is just going to set out who the parties need to be if all the parties aren't there, and or dealing with the appointment of an estate trustee. There are also situations where an estate trustee during litigation in a will challenge doesn't have to be appointed. Obviously, it depends on context and circumstance, but there are cases where you might be able to not have an estate trustee during litigation because the parties want to get to mediation, and all they need is documentary production and a freezing order over the estate. But maybe that can't happen. But these are the kinds of thoughts that that one may have in trying to decide whether to pursue an order for directions. I'm going to talk a little bit about orders for assistance. And orders for assistance are governed by Rule 74.15 of the Rules of Civil Procedure. And what's compelling about that rule is it can be used to force parties to take necessary actions to allow for or facilitate the administration of the estate, deal with certain potential disputes, and obtain certain kinds of orders, like a passing of accounts. And here's the rub about it. You can do it by way of a motion without notice. And there's one exception to that within Rule 74.5, and I'll touch upon that in a minute. But that's an attractive aspect of Rule 74.15 in orders for assistance. They can be obtained by way of a motion without notice. And as such, they can be cost effective. The ability to move quickly depends on court resources and court availability. I'd like to say that it means that you can have a quick result in terms of obtaining an order, but that depends on the jurisdiction you're in and how long it takes to get a motion. But it certainly can be cost effective, and it can be done regardless of the posturing of the target party involved. So let's chat about a little bit about what kinds of orders for assistance can be obtained. I would note that on page 2 of our paper, the types of orders for assistance are specifically laid out. Again, it's Rule 74.151, and then there's subsections A through I. There is a catch-all. I is a catch-all for an order providing for any other matter that the court directs. So typically, even when you go for an order giving directions, you'll reference that section in an order from the order for assistance rule. So where a person has not accepted or has refused his or her appointment as an estate trustee of an estate with or without a will, an order for assistance can be obtained requiring that person to declare whether he or she is going to accept the appointment. And that is subsection A under the rule. You could also require a person to object or consent to the appointment of an individual who wants to become the estate trustee. This can be an effective tool if someone is threatening to challenge a will, or someone is threatening to challenge an appointment pursuant to a will and is on the fence and isn't giving an indication. So this is when a will challenge hasn't necessarily been declared, and perhaps your client wishes to be appointed, but parties are saying, we're going to challenge, and nothing happens. And you can force them to declare whether they consent or object to your client's appointment. You can have, under this rule, an order forcing an estate trustee to file a statement with the court setting out the nature and the value of the assets of the estate as of the date of death of the deceased. And again, these would be the assets to be administered by the estate trustee. This can be an effective tool when an individual who has an interest in the estate has not been able to obtain a listing of the assets. Maybe your client is deciding whether or not to challenge a will, and they don't know what the assets are. So maybe this is a tool that could be used to determine what the assets of the estate are. And yes, there's a lot of issues that go along with that. There could be assets that were joint and should be in the estate, or wrongly obtained, potentially beneficially designated assets. So those are all complex issues that might affect it. But on the face of it, an estate trustee can be forced to provide a statement of the nature and value of the assets. It's also commonly used to obtain a passing of accounts order against a party. And so it could be that requests have been made for a passing of accounts. There's been no response. You bring a motion without notice and obtain an order that the party produce accounts within a certain period of time. The one thing about bringing motions that are ex parte, that is without notice, is that you may or may not get all of your costs. Sometimes you can get costs with it, but it might be a diminished kind of cost award. Obviously, costs being in the discretion of the judge will make the order. Going just back before I leave the comment on about an estate trustee being forced to produce a statement setting out the nature and value of the assets, if you don't like the response to the order and you want further particulars, Rule 74.15, more particularly 1E, allows parties to get an order for further particulars. This is the one, though, that does absolutely require the estate trustee to be put on notice. Because in this kind of case, you would have already received an order, you want further particulars, you need to put the estate trustee on notice. So this would not be a without prejudice, without notice pursuit of the further particulars. Also, there is the ability to have beneficiaries or spouses of beneficiaries who may have witnessed the will to provide evidence if there's a concern that there has been improper or undue influence with respect to the will. Also, under Section 17(2) of the Succession Law Reform Act, that particular section of the SLRA indicates that where there's except where there's a contrary intention appearing by the will, after the testator makes a will, if his or her marriage is terminated by a judgment absolute of divorce or is declared a nullity, if there is a devise or bequest to his or her former spouse, or an appointment of his or her former spouse as an executor or trustee, or conferring a general or specific power of appointment on his or her former spouse, those would be revoked further to Section 17(2), and the will shall be construed as if the former spouse had predeceased. Under 75151G, so yeah, there's a lot of letters and there are a lot of numbers and letters, but under that rule, you can get an order for assistance requiring the beneficiary or the former spouse, depending on what the issue is, whether it's 17(2) or not, to provide evidence and take part in the determinations that may be necessary. Also, 7415, that is orders for assistance, are in addition to Section 9 of the Estates Act. And Section 9 of the Estates Act allows one to bring a motion to the court seeking to have a person, doesn't have to be the estate trustee, or the person who's thought to be named in a will as the estate trustee may not actually be in possession of the will. So it is a motion that's brought to require a person who is in possession of or in control of a will or testamentary document, requiring them to provide that testamentary document to the registrar. And then therefore copies could be obtained of the court file. So orders for assistance allowing you to facilitate administration of the estate or consideration of initial information as to that may help you in or assist you in whether you want to make a will challenge, and Section 9 of the Estates Act. Now, again, if you're required to bring notice, then and that is again for further particulars, under the rule, you have to give 10 days notice. And you would have to serve the motion by way of personal service, alternative to personal service, or as the court directs. It is important to note that if you're going to bring this ex parte motion, you need to have full disclosure in your materials. If you do not have full disclosure, that could be fatal down the road to the order being set aside or varied. And so all of the relevant facts need to be put, because the court doesn't have any other source if you're bringing the motion without notice. And so sometimes these motions are brought and they don't contain the full disclosure, or they contain an unreasonable term. Say, for example, you want a passing of accounts and you go to court and you ask for 30 days, but it's extremely unlikely. Maybe this is a court passing for 20 years. And there's literally no realistic chance of having it for 30 days. Well, the recipient of that order, the one who is being required to pass their accounts, can have a lawyer bring a motion to amend the order seeking to extend out the time. So when you're bringing these motions, think about full disclosure, think about what's reasonable in the circumstances, and think about if you're exposed to a subsequent motion to vary or set aside the order. And with that, I'm going to turn it over to Tanisha now, who is going to touch upon mediation and orders giving directions.
Thanks very much, Craig. So what I want to drill down on is something that Craig talked about at the beginning, the idea that this is your opportunity to design your proceeding, to manage what the next steps of your proceeding will look like. So to begin with, an order for directions in the context of a will challenge may arise as a result of two different rules of the rules of civil procedure. It's either going to be Rule 7503 or under 7506. Under Rule 7503, the rules provide that at any time before a certificate of appointment of estate trustee has been issued, any person who appears to have a financial interest in the estate may give notice of an objection by filing with the court a notice of objection. And that's going to be under Rule 75.1. Now, this is going to be signed either by the person who's objecting or the person's lawyer, and it's going to state the nature of your interest and the nature of the objection. The notice of objection, as you know, will expire within 3 years after it is filed, and it also may be withdrawn by the person who filed it at any time before the hearing under Rule 7506. That notice of objection may also be removed by the court. Now, where an application for a certificate of appointment of estate trustee has been made and a notice of objection is filed, the registrar is going to send notice to the person who has filed that either by regular mail, to the applicant or the applicant's lawyer, and it's going to be sent to that mailing address that's included in your certificate, your application for the certificate. Any applicant who receives such a notice is then required to serve on the objector a notice to objector, and that's in Form 75.3, and that's going to be filed with proof of service with the court. Where an objector does not in turn file a notice of appearance within 20 days after service of that notice to objector, that application for the certificate is going to proceed as if no notice of objection was filed. And then a motion for directions is going to be brought. This is where your order giving directions is going to come into play. If the applicant doesn't move for directions within 30 days after service of that notice of appearance, the objector may move for directions. The other option for your order giving directions where that will come into play is, as I said, Rule 7506. And what happens there is that any person who has a financial interest in the estate, again, may apply for directions or may move for directions in another proceeding under this rule. And this is going to set out, as I said, the procedure for bringing the matter before the court. In an application for directions or a motion for directions, it's going to be served on oral persons who appear to have a financial interest in the estate, and it's going to be served at least 10 days before that hearing. Parties can, however, bring any, as Craig said, any motion or application on short notice if permitted by the court, and you can also, under Rule 75.06 sub 3, outline the directions that the court may give. So, as Craig mentioned, and I don't want to be too repetitive, just high level, that order is going to set out the issues to be decided, who the parties are, namely who is the plaintiff and who is the defendant, who is going to be submitting rights to the court, and the court can also order who is to be served with the order giving directions, the method, and the time of service. The court can also order procedures for bringing the matter before the court in a summary fashion where it's appropriate, and can also order that the plaintiff will file and serve a statement of claim, that an estate trustee during litigation might be appointed. The court can also set out what security has to be posted, and can also order any other procedure that the court may deem just. And we're going to get, as Craig said, into the actual form of an order giving directions, which is either going to be in Form 75.8 or Form 75.9 of the rules. One of the things that I want you to also keep in mind is that notwithstanding that an order for directions may be on consent of the parties, you should take note that the court may intervene and make directions of its own with respect to your will challenge. And this is regardless of the parties' intentions. This will come about more likely than not if certain parties are unrepresented, if there are parties that are under disability, or where there are persons with an interest in the estate that have not been included, either intentionally or unintentionally, in your filing. The court may also intervene if the relief that is being sought in the order is going to affect a non-party. For example, a drafting solicitor who's being named for examination, but that drafting solicitor is not before the court. You can almost assuredly expect that the court is going to want to understand if that solicitor is on notice and what interest the solicitor may have in certain terms of the order. Now, I'm going to go through a series of examples of areas where the court will make orders, and Craig has mentioned some of them as well, and I'll drill down into more detail. One of the areas is for mediation. So if a proceeding is subject to mandatory mediation, an order for directions will typically include the terms for that mediation, including the issues to be mediated. As we've mentioned, under Rule 75.1.02, if that proceeding is commenced in Toronto, Ottawa, or Essex, and certain criteria apply, then you're going to have a mandatory mediation. And those criteria can include certain types of proceedings. One could be an application to pass accounts if it's contested, applications for formal proof of testamentary instruments, objections to issuing certificates of appointment, applications for the return of a certificate, claims against an estate, and then generally any proceeding that falls into Rule 1405 sub 3, given that they are an issue that relate to an estate or a trust. Now, while it's possible to exempt certain proceedings from mandatory mediation by way of a motion, I want you to understand that that's not to be the expectation. The court presumptively views matters as being mediated, and so you'd have to have a very good reason for the court to make an order that your proceeding would not fall under the mandatory mediation regime. In areas where mediation is not mandatory, parties may wish to proceed by mediation because it's cost effective, it provides an efficient and quick or early way of resolving a dispute. But always remember that your decision as to when to go to mediation is going to be strategic. The timing of a mediation is going to be very important. And you might consider and make allowance for certain things when choosing the timing, such as whether you've got all the necessary documents and all the information exchanges have already taken place. You might also consider certain things that may have to take place before a mediation, or certain things that you don't want to take place before a mediation. For example, you may not necessarily need to have an examination completed of all the parties before mediation. It's entirely possible, and in some cases is preferable, that you have only certain parties examined. It keeps costs down, obviously. Perhaps you don't want the actual parties to the dispute examined before mediation, but you have all the documents that are necessary. You might proceed in that case. It may also be that you only want the drafting solicitor examined. Maybe that's the only critical piece of viva voce evidence that you want on the record before you go ahead with a mediation. In addition to specifying your timing of your mediation, the parties can also specify in their order who the mediator is going to be, place of mediation, who's going to pay for the mediation, and that can be a very contentious issues between the parties at first instance. And so it might be that for the purpose of your order, you may do something like either state the name of the mediator if you're able to get an agreement, or defer the decision down the road to the effect that it's going to be chosen according to the rules in due course. In terms of cost that I touched on, it may be that you take the position that costs will be paid at first instance from the estate and then leave the ultimate decision as to costs for the trier of fact. That may be a way to get your parties to a settlement discussion without the acrimony preventing any discussion up front. Another issue that can be dealt with in your order giving directions is who the parties are going to be, as Craig mentioned. And what that can turn on is whether or not a party has been represented or not. You might find that a lot of self-represented parties are before the court, especially with the sense of beneficiaries who may not necessarily want to hire a lawyer to deal with their interests. You can think of an estate that has a number of parties, a number of moving parts. You have to also keep in mind who is to be represented and whether you want to talk about that and deal with that upfront in your order. On this point, Rule 15 of the Rules of Civil Procedure deals with the various aspects of representation by a solicitor. According to Rule 15, a party to a proceeding who is under disability or who acts in a representative capacity shall be represented by a solicitor. Also, a party to a proceeding that is a corporation shall be represented by a solicitor, except with leave of the court. And finally, any other party to a proceeding may act in person or be represented by a solicitor. So there's that option for that section. In light of the above, if a person is acting as a representative for a party, perhaps formally, or his or her, like maybe in the context of a litigation guardian, or perhaps as a result of being somebody's power of attorney for property, that person must be represented by a solicitor. That being said, as I mentioned, in the context of an estate dispute, I think that's more likely than not that you're going to find the unrepresented party. And given the difficulty that an unrepresented party can place in terms of moving a matter along, not understanding the procedural necessities, you can get bogged down if you don't create, even if you're not the party who's dealing with the issue directly, you can get bogged down in your litigation if you're not thinking ahead and providing for that in the context of your litigation. And you also have to keep in mind that, the court is going to want to help that party along. So you're going to have a situation where the court will more likely than not intervene when there's an unrepresented party at the table. Now, what can you do to keep things going along if you have that self-represented party at the table? You can include directions in your order that sets out the process and the detail. And what that will do, while it may provide for less leeway for parties who have representation, there's always the opportunity to talk amongst counsel and revise orders as you go along as it's necessary. The fact that you put that kind of time frame in place while you lose some flexibility, you do create that detailed roadmap for the self-represented party to follow. And most importantly, as a represented party, you create a structure that you can enforce before the court. You can say more clearly to the court that everyone knew what had to be happening, everyone knew the timeline, and that gets you, to keep the process going more fluidly, as opposed to having to come back to court if there are, delays or excuses that are put forward by the unrepresented party, as sometimes has to happen because, as I said, parties may not know the process. Now, how do you help the unrepresented party along even further? You might sometimes find in a will challenge that the order provides that the self-represented party is to be represented. In some unique cases, we have orders that provide that the self-represented party's costs of a lawyer might be paid from the estate at first instance, again, subject to either resolution between the parties or a further order of the court. Also remember when you're dealing with a self-represented party that if you're able to resolve the matter and you have a settlement that has been agreed upon, any such settlement has to have the opportunity for that self-represented party to obtain independent legal advice if you're going to be looking to ultimately enforce that settlement. It's just a safety net that it's important that you consider. At this point, I'll turn it back to Craig to talk about parties submitting rights before the court.
Thanks, Tanisha. So where a party is served with a statement of claim or is a respondent in an application or motion for directions, and he or she decides that they don't want to participate in the proceeding, this can be affected by them submitting and delivering a statement of submissions of rights to the court. And Rule 75.07.1 of the Rules of Civil Procedure addresses the submission of rights to the court by a party. And where an individual decides to do that, they're no longer, once they've submitted that statement to the court, they're no longer a party to the proceeding. And they're only entitled to service by the plaintiff of written notice of the time and place of the trial and a copy of the judgment disposing of the matter. Okay, so that's what the rule says. However, if there is a settlement between the parties who remain in the proceeding, what happens then? Well, Rule 75.071C of the Rules of Civil Procedure further stipulates that a judgment on consent following settlement shall not be given by the court without the following: written consent of the person, that is the person who submitted their rights, an affidavit of a lawyer of record in the proceeding attesting that a notice of settlement, which will be appended rather to the affidavit, has been personally served on the person who submitted their rights. And Form 75.11 is the form that's served upon the person who has submitted their rights. So in other words, if a person doesn't want to be involved in the proceeding, they can do a statement of submission of rights and they take a back seat. But the parties can't come to a resolution with respect to the will challenge per se that might cut them out of any will that could possibly be valid, right? Then the court's going to say, well, wait a second, did they agree to this? Like, where do you get your, if you're saying the last will isn't the valid will, and it's the prior will, which is the valid will, are you saying that they don't get, what they're entitled to under the will? So what the court says is, wait a second, if you're going to come to the court for a judgment regarding a settlement, so you got to come back to the court, and so it hasn't been decided by way of a trial, then you're going to either have to do one of the following. You're going to have to get the consent of that individual, or they get served with the notice of settlement, which attaches a copy of the settlement agreement. And then Form 7511 says, person who has submitted their rights, you now have 10 days, or a lawyer on your behalf, to put in a rejection to the settlement. And then they might be re-engaged in the process because they've rejected the settlement. If they consent to the settlement, then the settlement just proceeds. So why would a person maybe submit their rights? Well, maybe they get the exact same thing under both wills. That is the will that's being challenged, the last will, and a prior will. So if they don't have a financial interest per se in the outcome, they might say, I don't want to be liable for costs. I won't be able to get any costs, but I don't want to be liable for costs about being in this proceeding. So that's a tool that can be used. That's different than someone who is self-represented and doesn't have a lawyer. Okay, someone who is self-represented and it continues to be a party in a proceeding is not filing a statement of submission of rights. Okay, and then I also wanted to chat quickly about whether to plead or not to plead. So as we've talked about, these proceedings are commenced by application or motion. But in the case of a will challenge, the parties may decide that they want to plead. That is, that they want a statement of claim and a statement of defense to set out the issues in a more fulsome way. So why do that? Well, it could be that one party wants to get all the allegations in the document out. And that might not be the case in a supporting affidavit for a motion for directions. A party can choose what they want to put in. But with an affidavit, there are certain pleading, or sorry, a statement of claim, there are certain pleading requirements. So you may want to do that. That will typically lead to, say, an affidavit of documents that might be required down the road. So maybe discovery process might be affected in a consequential way if you decide to plead. Why wouldn't you decide to plead? Well, one of the reasons is cost and necessity. If it is that this is a fight that, frankly, both counsel involved think should go to a mediation in a cost-efficient way, the parties could decide we're not going to have any pleadings at all, or they could decide we're going to leave the decision to plead until after the mediation. And if the mediation doesn't resolve things, you go back to court and you get an order with respect to having pleadings done. Okay, so the timing of pleadings doesn't necessarily have to be upfront and initial. It could be considered and negotiated by the parties and ultimately dealt with before a judge, before or after a mediation. I do want to share with you the paper, not for the purposes of going through the paper itself, but just to let you know about the chart and the draft order. So hopefully you can now see the paper that's on the screen. So as I mentioned, the first 15 pages, I'm just going to scroll over. That's the narrative portion of the paper that you can obtain by going to the link. Okay. Here's where I'm just trying to draw your attention to right now. There's about 6 pages starting on page 16 of the paper that deals with sample kind of provisions that one might consider for an order giving directions. These sample provisions are not in any way intended to be something that one would consider is mandatory, that one should consider is exhaustive, that this is anything other than simply a sample that one might consider in coming to an order for directions. Obviously, context and circumstances are going to demand that you tailor provisions to your intent, strategy, and negotiation vis-a-vis an order giving directions and the steps in the proceeding. But to be helpful, this chart was done in 2007 when this paper was initially delivered, but has been updated. But it's not intended to include every possible kind of clause or provision that could be out there. It's the understanding that at one time the judges on the estate list had charts of various provisions that might be included in orders for directions. So I'm not going to take you through all of them. I'm just going to scroll through to get to the sample draft order, but you can see, and this is sometimes helpful, just having the chart to say, okay, I'm doing an order for directions. Have I thought about all my considerations? Again, this chart is not exhaustive, but it can be helpful. A couple of the things that the chart doesn't include, because it's not exhaustive, is potential provisions for pleadings, the return of a certificate of appointment. If a certificate of appointment has already been provided by the court and a will challenge arises and an estate trustee during litigation needs to be appointed, well, then the certificate of appointment obtained by the estate trustee under the a challenged will should be returned to the court. So you may want to put a provision in about that. Also, inter vivos transfers, a litigation administrator for the deceased, clauses regarding the involvement of the children's lawyer or the public guardian trustee, whether you want responding affidavits or responding materials to be dealt with up front or not. So just wanted to put the chart into context and to say that it's here to be helpful, but certainly not conclusive, certainly not exhaustive, and needs to be tailored. If we then go to the end of the chart and on to the next page, there is a sample draft order giving directions. This again is not intended to be indicative of what you need to do in an order giving directions. This is just what one might look like if you were thinking about various issues. And so I'm going to scroll through and not go through each of the provisions because I'll allow you to do that if you wish on your own time. But the first clause deals with the issues to be tried dealing with the will challenge. Clauses 2 deal with an affidavit of documents. If the parties want affidavits and documents, maybe they're choosing not to have affidavits of documents. That's going to be for the parties to determine. And then submitting the parties to examinations for discovery. Paragraph 3 deals with examining the lawyer who drafted the will. Paragraph 4 deals with waiving solicitor-client privilege and duty of confidentiality if you're going to examine that lawyer. And then we're starting to get into the appointment of a state trustee during litigation clauses. And all of these clauses, 4, 5, 6, 7, 8, 9, 10, 11, 12, deal with the actual appointment, deal with obtaining a certificate of appointment of a state trustee during litigation, deal with waiving the requirement of a bond, deal with the powers, deal with the vesting of the assets into the ETDL. And then 13 is a paragraph that says that the estate trustee during litigation, I slip into ETDL as the acronym, will go ahead and get medical records, solicitor's records, records from OHIP, financial records, and that they will look after that, but the respondents and the applicants can get copies of that. Sometimes it's done this way so that both the applicants and the respondents in a will challenge are not writing to the same institution seeking records. Sometimes it's the estate trustee during litigation that does that on behalf of the parties. The estate trustee during litigation would get reimbursed for the costs associated with that production from the estate. Also, the compensation of the ETDL can be dealt with. Also, there can be a clause that says that the estate trustee during litigation may sell some properties or assets and may not sell others. It may be that certain assets are in dispute as to their ownership, as to whether the estate owns them or not, but they've been frozen, or they're vested in the ETDL for that purpose, but they can't be sold. Also, the estate trustee during litigation, according to this paragraph 14, will not be making a distribution of the residue of the estate without an order of the court. Paragraph 15 deals with the deemed undertaking rule. 16 deals with mediation, as Tanisha said, lays out how the mediation mechanically might take place. And then 17 deals in this order about if a mediation doesn't settle things, setting the matter down for trial. Paragraph 18 deals with a situation where one of the parties registered a caution on a property so that it couldn't be dealt with until the motion for directions was brought. Well, if they've put something on title and the ETDL needs to deal with it, whatever they put on title, here it's a caution, needs to be removed. So we're dealing with that as well. Then we're dealing in 19 with service of the order giving directions on the respondents. There's a paragraph here, 20, which I like to include, which says that the parties may revise the timeline set out in this order by their written agreement. So if the court is saying that things should be done in a time period, and everybody thinks that that's reasonable, but it turns out for whatever reason, maybe production's taking longer than anticipated, timelines have to be adjusted, this inclusion allows the parties to make a change in agreement, in writing, but without having the cost or the time needed to go back to court. And then, of course, the balance of the application is adjourned, and the parties are at liberty to obtain further orders and directions in paragraph 22, and then pushing off the costs of the motion to the trial judge, although you could deal with costs at that particular time. I'm in no way suggesting you need all these provisions in an order giving directions. Sample order here is to give you some thought as to, or sorry, our thought as to what might go into it. I've seen orders for directions that are one paragraph. I've seen orders for directions that are over 15 pages. It depends upon the simplicity, the complexity, and the strategy involved by both sides as to how they're going to get to a resolution or a decision-making process by way of the court. So I just wanted to point out that there's a narrative portion, a chart portion with sample provisions, and then a draft order that's attached. So I think at that point, or this point rather, it's a good time for Tanisha and I to stop the presentation and allow for questions to come forward from those who may have questions.
Greg and Tanisha, thank you very much. That was a great presentation. Before anyone else chimes in, I just have a quick question about the first court appearance. You know, as you've talked about, there's likely going to be a situation where there's going to be some order for the production of the will drafting lawyer's file. You know, the lawyer still has some sort of duty owed to protect privileged documents. Even if the person is deceased. Is there any situation in which the lawyer who prepared the will would actually have to oppose the request for productions of their file?
Well, typically, when the lawyers put on notice that somebody wants their file, and it's a will challenge, because we're dealing with will challenges today, so we're going to say in that context, that lawyer will contact LawPro. Okay, that's what my understanding is, that LawPro likes to see happen, is that if there is a legal proceeding that's going to be taking place, it may have been started, it may not have been started. Somebody might be making production requests even before that there's a proceeding started, but that lawyer will go to LawPro, and LawPro will assist that lawyer in a position to be taken with respect to a request or motion or application for production. That lawyer will almost certainly want a provision that waives any solicitor-client privilege and duty of confidentiality reposing in the deceased or the estate, so that those productions can be produced. And that's why in the order, I included in the draft order where there was going to be production by the lawyer who drafted the will, and there would be an examination by that lawyer, that clause was included. So if counsel who may not be experienced in will challenges bring an order giving directions and they don't put the lawyer on notice, that's sometimes when a judge steps in and says, okay, I'm used to seeing this clause in an order giving directions. Have you put the lawyer on notice? And if the proper provision is included in the order, the lawyer, if just asked to produce documents, may be fine with that. That will be for that lawyer to indicate. If there's going to be an examination of the lawyer, then judges, if there's not a name of a lawyer who's included, or even if there is a name of a lawyer included, will often say, has that lawyer been contacted? Why? Because the issue of that lawyer being examined and his or her costs simply incurred for participating in that examination and or the cost of their counsel can become issues. And so I haven't included a provision in the draft order dealing with the costs of the lawyer to be examined or of their counsel. That is an issue that can be in dispute, and one might want to turn to the case law on that, or the way that the courts deal with that. So yes, if the parties are ignoring the lawyer who drafted the will and are not including provisions that ought to be included, then yes, a production order or a request or provision to examine a lawyer may not be granted by a judge, and is often not. Judges are experienced enough to, having seen so many of these orders giving directions, that even on consent, like Tanisha was talking about, they may have their concerns and comments. And I've been involved in matters where judges have said, please put the lawyer on notice of everything that's going on.
And what I would add to that is, from the Law Pro perspective, from the lawyer's perspective, I'm always interested to understand what exposure the lawyer may have. So it's a will challenge. And remember, someone is suggesting that this will is not valid. There could be a question at play as to whether that lawyer has done something incorrectly, and a potential claim lurking in the woodworks for that lawyer. So that's why I would absolutely caution drafting solicitors to put Law Pro on notice before producing a file. Aside from the privilege considerations, the cost considerations, there could also be a potential claim that is sitting out there that you want Law Pro to be aware of.
And just one last comment on that, piggybacking on what Tanisha said. If somebody's trying to put a deemed undertaking rule exclusion in a draft order, the drafting solicitor may have an issue with that. And so that would be a reason for putting a drafting solicitor on notice as well. Other questions, Peter?
Yeah, there's one question I see in the chat. They're asking about orders for directions, and with that first court appearances, do you find that orders for directions are becoming more contentious?
Yes and no. And that sounds like a very lawyerly type answer, but I'll put some meat on the bones there. I typically think that order giving directions, except for maybe one or two of the issues, can be negotiated. And oftentimes orders giving directions do come on consent to the court, because counsel who dealt with and have experience with will challenges typically know the kinds of clauses that a judge is going to order. And so as a result, some of the things aren't really in dispute. However, on a more increasingly, experience, issues within a court order are becoming more contentious. Could be that assets wish to be frozen. What assets are being required to be frozen, as an example. And one lawyer believes that that's more an injunctive type relief. Another lawyer believes that that isn't injunctive type relief, that is a common thing with order giving directions. And so that's one area that I'm finding that there can be a contentious aspect to the appointment. Sometimes it's contentious, certainly over the appointment of an estate trustee during litigation. Who might it be? And who's going to pay for the costs? And issues like that can arise. So in many cases, orders giving directions can almost, in respect of all the provisions, be agreed to. But there are certainly instances where there are legitimate, reasonable issues that are in dispute between the parties and are contended, and then you go to a court to get the judge's comments on it.
What I would add there is this goes to the part of our discussion about the interventionist nature of some judges. You can expect that when you have a contentious order, some party is going to say, I don't agree to this, Your Honor, and I want a motion on the issue. I want you to keep in mind that the judge does have an expectation that you're ready to argue some of these positions. Some things will go to a motion, but the idea of the order giving directions and a judge that, you know, wants a process and wants to help the parties along is that you may be defending your position on the day. It's going to be, as Craig said, the judge is going to give you their thoughts. And if the judge thinks an order is perfectly reasonable, you may have that inserted into an order giving directions, even without the process of a further motion to argue a specific issue. You know, it can happen either way, depending on what the issue is and what the judge thinks is perfectly reasonable for this kind of situation and the facts before the judge on that day. So keep that in mind.
Absolutely, Tanisha. And a couple more instances, Peter. One is with the proliferation of cases over the years. There are far more self-represented parties than seemingly in the past that are and so by that I mean they're not represented by counsel. Typically, if there's a self-represented party and they don't have the benefit of any legal experience and they have not been involved in a proceeding, it may be very difficult to have any kind of consent with respect to an order giving directions prior to the first attendance. Even if you provide them with a draft order, even if you upload it to case lines, they may not be willing, perhaps sheerly and genuinely they don't understand the provisions. And so that could very well be contested. I do want to say, to Tanisha's point, I had a case last year where one of the parties wanted to have his client appointed as the estate trustee during litigation. And without getting to any of the contextual facts, we went to a court attendance and he wanted to bring a motion. And the judge said, this is so basic, Mr. Lawyer, I am not going to let you bring a motion. Your client is not going to be appointed as the estate trustee during litigation. So the parties need to come up with another name. We'll have another court attendance in 10 days. And you guys come and tell me what are your nominees for as an estate trustee during litigation. And so you might go into a court attendance thinking you're just simply asking for a motion, but in that particular case, the judge wouldn't even allow that motion to be brought. And so it had to be dealt with on that day. And it resulted in the parties on the court attendance agreeing to come back in 10 days with names.
Great, excellent answers from both of you, Craig and Tanisha. There's another question here that's somewhat similar. It may sort of bleed into what you were already talking about. The question is, do you find that orders for directions that are on consent will be granted on a motion in writing, or do judges prefer to have an oral hearing for questions?
Might not be the right procedure, but I prefer to take my consent order to an oral hearing. I can get it heard much quicker and get it signed that day. The right procedure, I'm sure, is to file it in writing if it's on consent, but there's a process to that. And I think there's a time delay to that, especially if you're looking for something, you know, on a fairly urgent basis.
And I would piggyback on that and saying it can be dependent on the jurisdiction you're dealing with. There could be a local practice, so always needing to check practice directions as to what might apply. But say, for example, in Toronto, if there's a scheduling appointment coming up with no motion before the court, per se for directions, but the parties have been able to consent to an order, then it would be uploaded to case lines before, so a judge could look at it before the attendance. And then counsel may well be able to get the consent order granted by the judge without having to bring a separate motion at all. So if within the jurisdiction, it's allowable and it's cost saving and it's time effective, an oral attendance that has already been like scheduled can be very effective to get your consent order.
Yeah, and I'll add to that, I've had success sometimes just calling up, Craig, like you mentioned, in other jurisdictions, it may be different. Regardless of the practice directions, I've gone to just calling up the estates court in a specific jurisdiction and posed it to them, what's going to be faster to get this urgent motion done, in writing or orally? And sometimes they've said in writing is going to be a lot faster. You're going to get a decision the next day. So I've taken that approach.
Yeah, certainly.
Here's another question. If a will challenge motion for directions is on consent, is it correct to say that an affidavit setting out the grounds for the challenge will still be necessary? So I guess another way of putting this is you've got a motion for directions and a will challenge. It's all on consent. Do you still need a supporting affidavit? And if so, do you need to set out what the grounds are for why the will is being challenged in that affidavit?
Well, I think it starts with what is the approach to the litigation, right? And litigation can be hotly contested. Okay, so I don't want to say that this is counsel being amicable and not vigorously taking their positions on a will challenge. But if the will challenge has been made, and counsel know that you need an order giving directions, oftentimes the quickest way to deal with things is to pick up the phone and speak to counsel on the other side, or send a letter, whatever is appropriate, asking if they're prepared to come to a consent order giving directions. Because typically there will be a court attendance that's looming. And so the parties are thinking, okay, we have a month to this court attendance. Are we going to bring a motion, or maybe 2 months, or whatever it is? Are we going to bring a motion, or are we going to try to come to a consent order? Taking into consideration the comments made on the last question, if counsel can come to an order giving directions, that is, both sides see the benefit of just coming to an order with the provisions that they would expect to be included in an order giving directions, and it's on consent, then no motion may be necessary per se. So no supporting affidavit would be necessary with grounds, because the proceeding has already started with the application for the will challenge. So a separate motion for directions in that scenario that I've just described wouldn't be necessary if the jurisdiction allows for a consent order to be brought on a scheduling appointment and before the court. So again, it's taking on board what you said, Peter, taking on board what Tanisha said and what I said about the jurisdiction, practice directions, whether you have an upcoming scheduling appointment, but the actual motion itself may be able to be avoided by counsel finding a resolution of the order giving directions in a way that is practical and reasonable. Again, the rules might require it, but the local practice may allow that if you have your application in respect to the will challenge, a separate motion may need not be brought.
Great. Thank you very much, both of you. We're about 10 minutes past the time. If anyone has a question that they wanted to pose orally, feel free to do that now. All right. I don't think anyone's going to be volunteering at this point. Again, thanks so much, Craig and Tanisha. It was an excellent seminar today. We really appreciate it. And thank you all for attending. Our next seminar is going to be about limitation periods and will challenges. That's going to take place on June 7th. 2023. Don't forget there's a certificate in the link to verify the CPD hours that you received for today's hour-long seminar. And if you haven't registered for that June 7th event, you can do that by clicking in a link that will be posted to the Zoom chat. Again, thank you everyone for attending, and we will hopefully see you in a couple of weeks.
Thank you again.
Thanks, everyone. Bye now.